So we have a motion for eviction on one and then a pretrial. Let's see.
I believe the pretrial is on January 7th, Your Honor. This is just the emergency motion for expedited hearing and immediate eviction.
Okay. Yeah, they got it down for pretrial as well. You may proceed.
Your Honor, as set forth in the motion, it's our information and belief that at a period of time since the original hearing, the residence was without power, despite our best efforts to confirm whether or not the power was on or the outstanding balance for the same. The estate was unable to do the same because the DTE and utilities had been switched out of the estate's name and into the defendant's name. Obviously, in light of the temperatures, the weather, there's a serious hazard as it relates to whether or not if the power has been on or whether the power has been off for a period of time. In light of that, we would rely on our brief and the affidavit in support of the same, requesting the court grant immediate eviction.
All right. Defendants want to make a statement?
The electric is on.
Yeah, like the power's been on. No damages have been done or occurred.
I don't understand what damages he's describing.
So I got an affidavit said on or about December 1st, I was advised there was no power at 404 Upton Ave. Asked Kristen and or Michael Harris. Time I confirmed through DT website that there was no outage in the area. On or about December 3rd, I contacted DT Energy regarding utilities for 404 Upland Ave. Provided copies of death certificates of Danny Amsbaugh as well as a letter of authority. Was not able to obtain utility information. Attempted to pay online, but was unable to do so. We were able to confirm that no utilities in the name of Danny Amsbaugh for 404 Upland Ave. So have the utilities been placed in your name, Kristen and Michael?
Yes, after my parents passed away, I put them in my name before any of these court proceedings began or anything like that because they died. So we needed to have them in someone's name that was living at the address. So that's what I've done.
The power's been on?
It was shut off
for a brief period.
Yeah, and then we paid the bill and it's back on, like it's been back on.
How long was it shut off? From what date to what date?
I want to say it was about a week and a half, I want to say, until we got it reinstated. But during that time, we also had CPS called. I was able to still keep the house warm with kerosene heaters. CPS came in, the water was still on and good because they checked all that.
The water, the lights, or well, not I apologize, not the lights. The gas was still on. Yeah. There was no damage was being done to the property.
So Danny passed away. Teddy. Who's the house?
I apologize, I didn't hear that.
Teddy is the
house in? Whose name is the house in?
It's still under Danny's on the property, given the pendency of the probate matter. Teddy has been assigned the personal representative of that estate.
And he's never tried to get in contact with us at all.
Our phone numbers have stayed the same, and we haven't had any contact with him.
Okay.
Not in a while anyway. There was about a month and a half ago, he quit talking to me.
So I guess, Mr. Morris, my question is, what is the immediate irreparable harm?
Well, now that the power is back on, I would have to acknowledge that there is no immediate irreparable harm. But at the time that the motion was filed, it was clear that there was no power. And given the temperatures in Michigan at that time, there could have been, not to mention the indication that they're using kerosene heaters clearly could cause irreparable harm if they're using kerosene heaters inside the house. Not only could that be detrimental to the property itself, but those individuals who are using the kerosene heater inside of the house. So I mean, there's a lot of areas of concern that could cause damage, but I would have to concede if the power is back on, that harm would be reduced. Granted, I don't know how long the power has been on or how long the power will remain on.
Right. So I guess my concern is, thankfully the house didn't burn down. Kerosene heaters, you can burn the house down. It doesn't sound like there was any fires or anything. And then the only question I have is like maybe the plumbing. Is everything working? Is there any busted?
Yes.
Yeah.
Are the toilets working? Are the sinks working?
Yep.
Yes, and CPS, they
CPS.
checked that when they were here, and they checked to make sure that the water was running, that it got hot, and all of that.
Yeah.
So I don't see health and safety risks. I don't see irreparable or immediate harm. So the plaintiff's motion, emergency motion for expedited hearing and immediate eviction is denied. We still have the pretrial, so we'll take this case up on pretrial. You said it's on the 7th.
I believe that was when we were previously notified for.
Let me check, confirm for you. 6-4-4-5. Mike.
I do have it as January 7th, Your Honor.
Says pretrial adjourned 1/7. Yep, 2 p.m. So yep, I'll see you then. Sure, it's
Okay.
before me. Yep.
Sounds good, Your Honor. Thank you.
All right.
Thank
Thank
you.
you. We're all set.
Yep.
Take care.
All right, thank you.
The landlord tenant case came after I filed suit against the landlord.
That's true.
And it's I believe it's retributive in nature.
Well,
So
retribution for not
to
paying the rent.
Just hold on, Adam. I think that I don't want to speak for you, Judge, but I think you're just saying that they should put an additional $250 into escrow to comply with the escrow order.
Correct.
In December, and again, given their need to vacate at their own cost because of the habitability issues, Mr. Goldman is certainly in his rights to claim that they owe additional money, and the jury will be the finders of fact on that. But I think that requiring them to continue to January, and I guess what would then be February, to pay another $800 or $850 a month into escrow for a house that they're not in possession of would not be fair, or in the purpose
So
of.
how much is owed outstanding? Because if rent is outstanding, it needs to go to escrow anyway. What's the alleged amount due and owing, Mr. Goldman?
I just need 1 second to pull up the lease, Your Honor.
And Your Honor, I respectfully, I think that escrow is not retroactive based on the amount in the complaint. I think it is they already have paid some retroactively, but that it's from the time of the filing or the order going forward.
No, that's not correct. It was from the time of the complaint, and the rent, let's see. There's an escalator clause here. So in 2025, it would be $850 with a discount for early payment. So there was no early payment for 2 months, which is why it was $1,800.
So it's current. So it reflects the amount owed.
And then that was October, November. There's December, and it looks like there's going to be January. Your Honor, I had a thought. Maybe what we should do is shut down the LT case, since we're all in agreement that they're going to leave, and they could proceed on their GC case, which contains all their same claims. I don't know.
Your Honor, they have a timely filed and paid jury demand, and they have their opportunity to file counterclaims based in the LT case.
I understand. There's a process to leave if the place is not quote unquote habitable. Have they followed that process? Because they just can't come here and say, I'm going to leave, and think they can escape 1 month's rent.
They finally paid out of pocket themselves over $600 for a mold report, and it came back with the severity of the conditions. I mean, in terms of compliance, there hasn't been an inspection of this property since, as far as I can tell, 2019. And now they've determined at their own expense and at the cost of their own health of having stayed there that it's not safe to be there anymore. They finally have lined up somewhere to go at the end of this month, and that's what they're doing.
When the time comes, Your Honor, the court will hear that that Adam fought against city inspectors, put up signs saying no inspectors are coming here. I attempted very hard to get the place inspected, and they absolutely refused to have any inspectors come by. So
That's
we'll get
not
that
true
time
because
coming.
inspectors have been through our house
Hold on.
multiple times.
Hold on, I'm just trying to figure out, I understand what you're saying, Mr. Fair, but if there's a process to vacate and it hasn't been followed, they're still liable for that January rent. And you have not answered any one of my questions, have they followed it? So I'm going to order them to pay January rent. Obviously, if Mr. Goldman's not entitled to it, it'll go back to them. But I have not heard you flesh out the legal process of them leaving on this record. So they're still liable for that January rent because it hasn't been a 30-day notice.
Adam, when did
So
you
until,
get
hold on, Mr. Fairley, until you prove otherwise, they're gonna have to pay the eighth, they have to catch up, they're gonna have to pay January rent.
if I
But this court does not work off hearsay, this court does not work off feelings and what we think happened. It's not what you said happened, it's what you proved happened in courtroom 203, and nothing's been proven. So I'm gonna order that, they're gonna come in, they're gonna put another $250 on it, and then now Mr. Goldman knows that they're leaving, and so they won't be liable for February rent. All right, so we'll come back February 2nd, 2 p.m. on Zoom. You know, I'm not going against anybody, but we follow the law in this court, and none of the law that I've heard has been followed. Okay?
Yep.
All right.
Your Honor, just for
So-
clarity, the January 5th date is no longer. Is that correct?
No longer, because I want to look at both cases and figure out what's the best path forward.
I thought that's what you said, just making sure.
Yeah, and then even if we get rid of the landlord tenant case, there can be a jury trial in the GC case, so they're not losing their jury rights. If I decide to say, okay, let's just go with the GC, we'll keep the jury for the GC.
Right, it'd be different.
Okay, all right, so February 2nd
2 p.m. on Zoom.
at 2 p.m. on Zoom.
Yes. All right, so we're all set.
Okay,
Thanks,
All
Your
right,
Honor.
thank you.
thank you.
Thank you.
Happy holidays to all. And Ben,
Happy
call
hol-
me anytime.
Sorry, Ezra?
Call me anytime.
You bet.
All
All
right.
right,
All
put
right,
this,
take
but
care,
put this,
everyone.
hey, make sure you get this one on your calendar with the right date, so I don't have to call you.
It's correct now.
Okay, very good.
Thank you.
Thank you.
Thank you.